The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated, everyone. We are set for 3 oral arguments today. We will take a brief recess between the second and third. The first case is City of Ames versus Iowa Public Employment Relations Board and Local 234. And it looks like the parties are ready. Mr. Craig?
May it please the court, opposing counsel. Under the Federal Transit Act, a public employer's receipt of federal transit funds is conditioned on the public employer preserving and continuing existing collective bargaining rights for transit employees. In 2017, when the legislature amended Chapter 20 to significantly restrict bargaining rights for the majority of public employees, they added a new provision in the code, Section 20.32, which basically states that all of the provisions applicable to public safety employees in Chapter 20 would apply to transit employees if it was determined by the Director of the Department of Transportation based on written confirmation from the United States Department of Labor that federal transit funds would be lost if those rights were not provided. The narrow issue presented in this case is whether that code section 20.32 has any applicability whatsoever to non-transit employees, and specifically whether a public employer is required to provide expanded public bargaining rights to non-transit employees who happen to be in a bargaining unit that has at least 30% transit employees. PERB and the district court answered that question in the affirmative, said they do have to provide those expanded rights. We submit that they were wrong and need to be reversed for 2 reasons. The first is that the plain language of the statute shows that it only applies to transit employees, not non-transit employees or whole bargaining units. And number 2, the conditions precedent of that statute were not satisfied in this case. And I'll start with the language of the statute. There was quite a bit of discussion in the briefing about whether the statute is ambiguous or not. I would submit that any ambiguity in the statute relates to what rights are provided pursuant to Section 20.32, what provisions of Chapter 20 apply pursuant to 20.32. But the issue in this appeal is really who receives rights pursuant to Section 20.32.
As I read Chapter 20, it strikes me that the sort of gist of it is that public entities would negotiate on a unit basis and not sort of particular job types within that unit. And so you have the 30% public safety employees, and that's the trigger. So even if there's 31% in a particular unit, everyone in that unit, so the other 69%, still get those same rights. Why wouldn't that transfer to this situation that you're addressing here?
Yeah, that's a good question, Your Honor. It's clear that for most employees, their bargaining rights are determined based on the composition of the bargaining unit. But in this case, the court in 20.32 specifically carved out transit employees and granted them specific rights as transit employees because of the unique federal protections that apply to those employees. They didn't say in 20.32 that it applies to bargaining units containing at least 30% transit employees. It says it applies to transit employees. And the interpretation that's been advocated by PERB and the union, which you just mentioned, that the 30% threshold should carry over and apply to transit employees, I think would be contrary to the intent of the statute. The statute 20.32 is intended to basically preserve federal funds by granting expanded rights to transit employees. If you apply that 30% threshold to transit employees, there will be transit employees that are in a bargaining unit with less than 30% transit employees who won't get those expanded rights, and you would lose federal funds. The whole purpose of that statute is to preserve federal funds, so that interpretation we would submit is just incorrect.
problems with doing separate bargaining within the same unit?
Recognize that in the ASME case when they upheld the 30% trigger or threshold, but they can certainly be overcome. And here the legislature has dictated that transit employees are going to get potentially different rights because of the federal protections that apply to them.
Related to that, I'm not sure that PERB's interpretation solves kind of the intra-unit bargaining differential. So as I understand it, what PERB says is that the non-transit employees have to be treated as public safety employees, but those people still have less bargaining rights than the transit employees, right? I mean, so we're still at the same position of intra-unit differences. And am I misreading PERB? And I'd like your opinion on that.
Either interpretation, you're going to have different rights within the bargaining unit. Transit employees are going to have the pre-2017 bargaining rights, and non-transit employees in that bargaining unit are either going to have public safety bargaining rights if they're in a bargaining unit that has more than 30%, or they're going to have the regular public employee bargaining rights if there's less than 30%. So there's going to be inconsistencies in the rights regardless.
Right. The public safety rights do not apply to transit employees because Department of Labor has determined those are not sufficient. So that's why you have to do the 20.27 pre-existing rights. Is that right? Okay.
Labor said that did not, even those expanded public safety rights didn't preserve the original rights, so that wasn't sufficient to preserve several federal funds.
2032 was triggered at all? I mean, doesn't it require, by its express terms, this written confirmation from the United States Department of Labor? Did that happen?
Honor, and what's been argued by PERB and the union is that all that's required to trigger Section 20.32 is a determination that federal funds are jeopardized. But that's a misreading of the statute. We don't dispute that federal funds were jeopardized because of the 2017 amendments to Chapter 20, but what the condition precedent of the statute actually is, it's not just written confirmation that federal funds will be lost. It's written confirmation that federal funds will be lost if the transit employee is not covered under certain collective bargaining rights, referring to the potentially applicable public safety bargaining rights. In other words, the Iowa DOT has to determine, based on written confirmation from the Department of Labor, that unless some or all of the expanded public safety rights will be provided to transit employees, the federal funds will be lost. And it's that second piece that didn't happen here. Because if the employer would lose federal funds, even if the public safety bargaining rights are provided to transit employees, then obviously the DOT and the Department of Labor cannot make a determination that federal funds will be lost if those rights are not provided. And that's what happened here. The Department of Labor determined even providing those public safety rights isn't good enough to preserve federal funds. So the statute doesn't even apply in the first place.
Elections, when for the city of Ames in this union, if you've got transit employees and non-transit employees, and then the transit employees are spared the more frequent, certification or decertification votes.
Treat it as a subunit within the whole bargaining unit.
I mean, it seems to me you're going to have two different negotiations within the same unit, right?
Because they would have different mandatory topics of bargaining. You'd have to do that.
Bring this to life. Who are the transit employees? Your city bus drivers? Anybody else? Okay. And then give examples of the non-transit employees that are in that bargaining unit.
City engineer or public works folks. So I guess going back to where I left off at, I think the language is clear that the 20.32 only provides rights to transit employees. It's basically a mechanism to provide additional bargaining rights to those transit employees if doing so is necessary to preserve federal funds. So whatever rights it bestows those rights on transit employees, not non-transit employees. And the statute is completely silent about providing any provisions about relating to public safety employees to non-transit employees or whole bargaining unit. It's clear that it only applies to any transit employees. And the purpose of the 2017 amendments to Chapter 20 were to restrict bargaining rights for most employees. Section 20.32 is kind of an exception to that basically allows expanded bargaining rights to be provided to transit employees if necessary to protect federal funds. But federal funds are not tied to providing additional rights to non-transit employees. So if you interpret Section 20.32 broadly to afford expanded rights to non-transit employees, it doesn't, one, advance the purpose of 20.32, which is to preserve federal funds, because federal funds don't care about the non-transit employees. And two, it's contrary to the overall intent of the 2017 amendment, which was to restrict, not expand, public bargaining rights. So for those reasons, we would ask that the court reverse the decision of PERB and the district court and hold that Section 20.32 has no application to non-transit employees.
About done. If we were to interpret the statute as opposing counsel is requesting, could it encourage some shenanigans as far as how the units are made up to try and cover all of the non-transit people, get them in a unit? Could any of that go on? Or I'm not quite sure of how the units are established, if they can be changed.
Be a risk, Your Honor, in allowing that to happen, that they could, purposely form the units in a way that reaches that 30%
Expanded bargaining, right?
transit employees.
Under the 2017 law in general, isn't it?
Thank you.
Follow-up question. Other than the issues relating to certification, decertification, what subjects of mandatory bargaining are different between public safety employees and the transit employees?
Use checkoffs would be one that was removed as a subject of mandatory bargaining for all employees, not just public safety employees. I think those are the main ones, the recertification and the union dues checkoffs. If there's no other questions, thank you.
Mr. Ranch, are you going next? And I assume you two will decide who gets how much time.
Thank you, Madam Chief Justice, and may it please the court. I am David Ranscht from the Attorney General's Office. I represent the Public Employment Relations Board. With me is Jay Smith. He represents the International Union of Operating Engineers, Local 234. That is the union that is the bargaining representative for this specific bargaining unit of city employees. To start off, I just disagree that the words certain collective bargaining rights in 20.32 means public safety bargaining rights. It doesn't say that. It says certain collective bargaining rights, and I think that's the fundamental misstep, and it is the basis of the city's entire argument, and it's wrong. Certain collective bargaining rights refers to the rights necessary under federal law to preserve federal funding. And that was the goal of the legislature in passing both 20.27 years ago and 20.32 more recently. So this case, and specifically 20.32, it's not an either or proposition about what rights are provided versus who gets them. It's both what rights are, what's necessary to comply with federal law, and who is the unit, not the individual employees, because that's consistent.
Subsection 30 or section 32 worded in terms of employee rather than unit. It says shall be applicable on the same terms and to the same degree to any transit employee. It doesn't say any bargaining unit containing transit employees. So where do you get from that employee language to the unit?
Section 20.32 itself doesn't afford any rights. It is a procedural mechanism by which to determine what rights the transit employees have. What it really has happened here is kind of a linear series of steps that preserve federal funding. At least that was what the legislature was attempting to do. And you can do both steps. They kind of got collapsed into one here, but when you unpack it and look at both steps, you apply them both. There's this initial mechanism to try, that's 20.32, and then there's a more muscular fail-safe if that doesn't work. So, yeah.
As I understood it, wait, are you saying now that the non-transit employees should have the same bargaining rights as transit employees?
Not necessarily, but Your Honors had some concerns about intra-unit differential, and so I think that's permissible to have intra-unit differential in this specific instance. And here's why. It's because when we get to step 2 and we get to 20.27, you're only deeming statutes inoperable insofar as the fund is jeopardized. So notwithstanding what AFSCME said about the difficulty with intra-unit bargaining, this is, in my understanding, a limited scenario that is kind of limited to its facts with transit employees and the preservation of federal funding.
The federal law is concerned with protecting transit employees, and that goal is not jeopardized if non-transit employees don't get the same rights.
That, but the fact of non-transit employees getting the rights available to public safety units is just a result, like that is what happens when you apply the framework here. I want to.
And what's your response to the other side, that in units where there are less than 30% of transit employees, then there are transit employees that lose out? And
Any transit employees that lose out. Think of it as it's imprecise, but you have almost a 3-tier system, right? At the top is the pre-2017 version of Chapter 20, right? Then you have public safety under the 2017 version. Then you have the catch-all, non-public safety, right? So depending on the composition of our transit unit, we're going to have either a combination of top and middle or a combination of top and bottom. The transit people will always get the top. To follow up on this kind of framework.
Yeah. I'm looking at 2032. I'm not sure where I can find this 30% threshold that PERB is relying on with respect to the unit, and why certain units would, non-transit employees in certain units would be entitled to public safety rights, and non-transit employees would not be in other units. I just don't see the language in there. Where are you getting the threshold requirement from 2032?
So 20.32, this is kind of the first try here, right? It has this, we'll call it a replacement effect, right? Once you have a Department of Labor saying the transit employee is not covered under certain bargaining rights, meaning what is necessary to preserve the funding, then you say, okay, we're going to treat the transit employees in the unit like public safety, and now let's go look at that. So now you go to 20.9 and you say, look at the threshold. These are transit employees wearing a public safety employee name tag, and now we've got the unit made in that.
It's a section 20.3, not section 20.9. I don't.
Unit, and 20.3 doesn't define the threshold. It just defines what a public safety employee is. So the order of operations is 20.32 cross-reference to 20.3. Go to 20.3, we've got the definition. Okay, where does that definition appear? That definition appears in 20.9. That's the threshold, and that's the subjects of bargaining. I want to back up a second and look at 20.27 because I've characterized that as a fail-safe, and I want to emphasize just kind of what an awesome power that statute is. That is a break glass in case of emergency statute. It is the power to wipe away and just deem inoperative statutes, and most of the time, heck, only you all can do that. But here, the parties and the board can make that agreement and utilize that statute. And so it makes sense that the legislature would want the relevant parties and actors to try something short of just striking or ignoring parts of the code first. So under the kind of framework you look at, certain collective bargaining rights, that means what they're entitled to continuation and preservation of under federal law. Are the transit employees covered? No. Let's go to 20.32. That means we use this replacement effect. The transit employees are public safety employees. Okay, we've gone 20.32 to 20.3 to 20.9. Now we look at the unit. The unit has 30% or more public safety, which means it's a public safety unit.
Factually, if there's one transit employee in a unit, does that provide the whole unit with the special benefits that the transit employee has?
If there's one transit employee, we would have what I was discussing with Justice Oxley. We would have a unit that is comprised of one person at level 1 and the rest of the unit at level 3, because the threshold of 30% isn't met. But once we create that unit, once we treat the transit employees and then determine what the unit is, we have the unit. Start over. Go ahead.
If we're willing to slice and dice, if it's less than 30%, why not slice and dice if it's more than 30%?
Dicing if it's more than 30%.
30%, the whole unit, even the non-transit employees got the transit employee benefits.
If it is more than 30% transit, the whole unit gets public safety, gets tier 2.
Following up on that, as I read the PERB decision, it sounds like we're solving a very practical problem about intra-unit bargaining differentials. And as I'm hearing you today, I don't understand what problem this interpretation solves. All the same issues about differences in bargaining rights within the unit still exist even under your interpretation. And as between different locals, depending on the threshold of transit employees under your interpretation, you have people who are similarly situated who get different bargaining rights. So I don't understand the practical problem that PERB thinks it's solving here, because it doesn't look like to me it's solving any issue.
The practical problem of intra-unit bargaining?
How it was couched was we have to have this interpretation because it solves this intra-unit bargaining differential, and it doesn't seem to me that it solves anything.
We're solving is more of an institutional one, almost a structural one, because we're making sure that every part of the statute takes effect, every part of the statute applies. We're not reading things out. We're not just being like, oh, this is inert. You only do that at step 2, and that's for a different reason. So that's the practical problem we're trying to.
As 2032 starts out by saying all provisions of this chapter apply or applicable to, why is it that we need to apply all of chapter 2?
And then when you get to 20.27, you're only rendering inoperative the provisions insofar as the fund is jeopardized. So,
My question, Mr. Ranscht, I mean, it says provisions shall be applicable on the same terms and the same degree to any transit employee. It's kind of like with the concept in contracts of third-party beneficiary. The only beneficiary here is the transit employee, not the bargaining unit that happens to contain transit employees. It's not worded as a replacement provision, which is the way you characterize it. It doesn't say wherever this chapter refers to public safety employee, it means transit employee throughout this chapter. Something, if there's a written determination by the Department of Labor. That isn't how it's worded, right?
Maybe my terminology was a little imprecise, but I'm not saying that it replaces, it's not a replacement provision. I'm saying it has a replacement effect. You treat the the transit employee as a public safety employee. But all provisions of this chapter, yes, that's in 20.32. 20.27 only renders inoperative the things that jeopardize the federal funding. 20.32 itself is not jeopardizing federal funding. What's jeopardizing federal funding are the substantive bargaining rights in 20.9 and the recertification requirements elsewhere in the chapter.
Who are the beneficiaries? Who's it applicable to? Only the transit employees under these terms. I mean, not everybody that happens to be in their unit, right?
As the court said in the 2019 decisions, that this sort of unit basis computation, that is permissible, even in that context where it was a constitutional challenge, relied on public safety versus non-public safety, and saying, hey, there are some public safety folks here that won't end up getting expanded rights because they're not in a unit with the threshold. I mean, you're just going back to that.
I mean, it was a rational basis test. We said it was rational, but we didn't say that you couldn't have other provisions of law that in specific circumstances, like in Ames with transit employees, led to a different result, right?
That's right. This isn't a constitutional case, but it is essentially a flow chart, in my view. Step 1 is 20.32. Step 2 is 20.27. Step 3 is that once you do that, the transit folks get the coverage that is required to preserve the federal funding. The legislature thought that was so important that it made 2 provisions about it. And the net effect of that, there's no mechanism to bump the unit down once you've established it.
Step 1 by the conditions to trigger Section 32. Could you respond to your opposing counsel's argument that you need the letter that you don't have and you need the other certification?
It's form over substance.
Statute says.
Upon, which is temporal. So DOT can't essentially refuse to make a determination upon written confirmation by the Department of Labor. DOT can't say we agree or disagree with Department of Labor. Department of Labor is a federal agency that gets to apply and interpret federal law and administer the funds. So upon is temporal. DOT is a conduit. DOT, or DOL in this case, in fact, issued a letter that said, hey, we have concerns. And to say that we are missing the conditions precedent to this statute because we don't have a document titled written confirmation from the Department of Labor upon.
The same thing as you are losing federal funds?
I guess I'm softening what DOL said. DOL said you'll lose federal funds if you apply House File 291. So under the record, as I understand it, we have the confirmation from the Department of Labor, although not titled written confirmation pursuant to Iowa Code 20.32. But let's look at substance over form. I need to let Mr.
Determination by the Department of, the Director of the Department of Transportation.
The determination by the Department of Transportation. We have this affidavit where he says, they don't issue me written confirmation because I asked for a thing called written confirmation and they don't issue those things. Again, that's form over substance. The matter here is.
He goes on to say this section, meaning 23.2, is not applicable. I mean, that is exactly his words, right, in the affidavit?
And this is Chapter 20, and Chapter 20 is PERB's statute, not the DOT's.
Legislature specifically put a role in there for the Director of the Department of Transportation, right?
It's a conduit. It's perfunctory. It's did DOL say the thing they said? It's not do I agree or disagree. You can't have. I'm not saying that the director here is doing this, to be clear. But you couldn't have a director of the Department of Transportation say, I've got written confirmation from the United States Department of Labor, but I'm refusing to make that determination under Section 20.32 because I don't think that the state should be accepting federal money. And so I unilaterally, as the head of the head of the department, I'm going to refuse to make the determination, make it impossible for the conditions to be satisfied, and thereby have that effect.
Determination by the Director of the Department of Transportation, that's surplus.
But it's much, much, much better than having a provision of the code than having 2032 just be not apply at all. I need to let Mr. Smith have his few minutes. Thank you.
Madam Chief Justice, Justices, Counsel, if it may please the court. Justice May, I think we'll start with your last set of questions. There are two things I think at issue, which the city has pointed out, the written confirmation and the determination. And you have to look at the appendix on page 247. This is a letter from the DOT's attorney basically recognizing that we have a problem with receipt of federal funding given the HF 291 amendments. Okay? The director and the city want to take the position, well, that's not the correct form. They didn't specifically say it, but when the legislature passed the act, they knew 13C had this interactive process to arrange for protective agreements. The second problem then with the affidavit, which the city relies upon, is that how can you make a determination that 2027 applies to protect federal funding if you don't make a determination that 2032 applies? You have to, one determination for one should be good enough for the other. And it's upon, you have that written confirmation in appendix at 247, and then you also have it in the letter from the Department of Labor at appendix 252, which was exhibit G before PERB. Now,
is different. I mean, it says, one says jeopardizing federal funding, and then the other has this specific language about written confirmation and determination by the Director of the Department of Transportation. I mean, we don't write these statutes, nor do you. We just interpret them. Yeah.
but I think the written confirmation, you have to look at what really happened here. And I think that's the problem when we get into the weeds in this case. This statute is a procedural statute. No fundamental substantive bargaining rights are conferred by it, which is what 13C is concerned about.
In the normal course with public safety employees, if there's more than 30%, I think that in the AFSCME case, the court said, that makes sense because we don't want to have this intra-unit sort of slicing and dicing, right? Having some employees that get bargaining of a certain sort and then others that are negotiating over different terms. But here, it seems to me that we're doing that slicing and dicing in every instance. The question is only whether the non-transit employees are getting heightened benefits or not. But the transit employees are getting different topics negotiated every time. So there's always going to be this sort of slicing and dicing. Am I understanding that correctly?
May I answer? I'm out of time. Thank you. I think you're correct, but two short points. Number one, the legislature is recognized by this court and AFSCME wanted to treat bargaining rights on a bargaining unit basis, okay? Number two, 20.177, which wasn't amended by the 2017 amendments, always allowed for some type of supplemental bargaining if the parties agreed to that to address particular issues. And to that extent that there's some supplemental bargaining after you apply 2032 and then 20.91, that's okay under the statute. Thank you.
Back to you, Mr. Craig.
Thank you, Your Honor. I think the ambiguity that's rose to this, that created this dispute is based on the language in 20.32, which makes applicable to transit employees those provisions of Chapter 20, which are applicable to public safety employees. And I think as PERB and the union have pointed out, under Chapter 20, substantive provisions and bargaining rights are applied on a bargaining unit basis. So there's a little bit of an incongruency in the statute. PERB and the union have addressed this by doing what Justice Mansfield had mentioned, which was basically just taking wherever you see the term public safety employee and inserting transit employee into the statute. And so they're saying, well, Section 20.91 is a provision that applies to public safety employees. So we're going to apply that to transit employees, and that 20.91 has this 30% threshold. So we're going to say that transit employees only get additional rights if they're in if they meet that 30% threshold. I would submit that that could not have been the intent of the legislature in adopting 20.32. Because it would mean that transit employees in a bargaining unit with less than 30% transit employees would not get those expanded rights, even if they were necessary to preserve federal.
That's where 20.27 comes into play, and it would protect them there.
Stop, but I can't imagine the legislature would have adopted a provision knowing that it would be inoperative and have to be basically fixed by 20.27. The whole purpose of Section 20.32 is to provide expanded rights to transit employees if necessary to preserve funds. Interpreting that statute to deny transit employees those additional rights just because of the composition of the unit would be completely contrary to the purpose of that statute. I think the better interpretation, Your Honors, is that when the legislature stated that the provisions applicable to public safety employees would apply to transit employees, what it meant was the provisions applicable to public safety employee bargaining units, the expanded bargaining rights that apply to public safety bargaining units, those rights would apply to transit employees. That interpretation is consistent with the purpose of Section 20.32, which is to provide expanded rights to, quote, any transit employee when necessary to preserve federal funds. But even if you were to accept PERB's argument that Section 20.32 makes the 30% threshold in 20.91 applicable to transit employees, that would be of no help to non-transit employees, which is the issue on this appeal. Section 20.32 makes the provisions applicable to public safety employees applicable to any transit employee. At best, that 30% threshold would apply to transit employees and give them additional rights if they had at least 30% transit employees.
20.32 really just only applies to transit employees, and so it's okay, we just do the intra-unit distinction and apply whatever 2032 would give only to the transit employees within a unit and do kind of the subunits that you're talking about earlier.
What the legislature said in 20.32, they were applying whatever rights they get, they're applied to transit employees, not non-transit employees, not bargaining units with transit employees, to any transit employee. That's the system the legislature set up because there are federal protections that are unique to transit employees.
Approach jeopardize any federal funding?
Approach,
Interpretation put at risk any federal funding for the city?
Department of Labor did determine that applying public safety bargaining rights to transit employees would not preserve federal funds. So that's when 20.27 had to step in.
You're a transit employee, you're a bus driver, you get the pre-2017 bargaining rights. Okay, yeah, got it.
Enough unless there's any more questions. Thank you.
The case of City of Ames versus Iowa Public Employment Relation Boards and Local 234 is hereby submitted. The next case, we'll have the lawyers switch here, State of Iowa versus Booker.